My residence document expires on Friday. AMA has not said yes, no, or even whether my application still exists. Can I leave Portugal? If I leave, can I get back? That is the kind of message appearing in expat forums every week. Months of silence, an expiring document, a phone line that provides no usable answer, and one terrifying question. Am I approved, refused, or simply forgotten? That question is where dangerous assumptions begin. Silence can be important, but silence is not automatically approval. Today, we are going to treat it as a proof problem. Build the record first, escalate second. Welcome to Portugal Rights Rebel, episode 84. I'm Elena Vargas. Today, we tackle one of the most common nightmares expats face in Portugal and show you exactly how to fight back legally and effectively. We will look at what administrative silence can mean, what it cannot prove, how to create a silence file that a lawyer can actually use, and when professional escalation may be justified. Your rights don't disappear at the border, but protecting them requires more than waiting, guessing, or sending another frustrated message. Let's clear away the most dangerous misunderstanding first. A delayed answer is not necessarily a formal refusal. It is also not necessarily approval. In Portuguese administrative law, people may discuss a lack of decision, administrative omission, or presumed approval. Those ideas have different meanings and different consequences. They do not form one universal rule for every immigration application. So if IMA, a municipality, a consulate, or another public authority has not answered, do not tell yourself, that must mean I won, and do not tell yourself, there is nothing I can do. The useful question is narrower. What procedure did I start? Which authority was responsible? What decision period may apply? And what evidence shows that I asked for a decision? That is the difference between frustration and a record. The Código do Procedimento Administrativo provides a general framework for public administration and decision-making. The Código de Processo nos Tribunais Administrativos, or CPTA, may become relevant when someone asks a court to address an authority's failure to decide. But naming those codes does not answer the question for your individual case. A court request concerning inaction is not automatically an order granting residence, permission to work, or a travel document. That distinction matters enormously. Now, let's build the silence file. Start with the receipt. Save the application confirmation, process reference, payment record, appointment notice, and uploaded document list. Then, save the portal screen showing the current status. If the portal allows downloads, download them. If it does not, preserve dated screenshots and note exactly when you captured them. Ask yourself one uncomfortable but useful question. If that portal changed tomorrow, could you prove what it showed today? Next, add the documents that establish who you are in relation to the procedure and what was submitted. Add correspondence, emails, contact form confirmations, registered mail receipts, delivery records, and replies from the authority. Keep originals unchanged. If you create translations, summaries, or highlighted copies, place them beside the originals rather than replacing them. A phone call can matter to you and still be difficult to prove later. Write down the date, the number used, the department if known, and what was said. Then follow up in writing. Thank you for today's information. Please confirm whether I understood the status correctly. If nobody confirms it, label the call as an unverified contact. Your memory is valuable. A timestamp, a receipt, or a written response is stronger evidence. Put everything into a chronology with 5 columns: date, event, authority or person involved, evidence number, and consequence or next step. March 3rd, application submitted, evidence 1. March 10th, payment confirmed, evidence 2. April 14th, additional document requested, evidence 3. April 20th, document supplied, evidence 4. Keep going until today. Name files so another person can understand them immediately. 2026-0303 application receipt. 2026-0420 upload confirmation. 2026-0502 status request. Number the evidence in the chronology. A folder full of screenshots is not yet a case file. A folder with a clear sequence is something a lawyer can assess in minutes. Then calculate the decision window carefully. Do not begin with, "It has been a long time, so the authority must be acting unlawfully." Begin with verification. Identify the authority named in your receipt or official communication. Confirm the procedure you actually started. Locate the current rule or official guidance that may govern the decision period. Record the date from which the period may run. Now, check whether anything affected that calculation. Was a document request issued? Was the file considered incomplete? Was there an interruption, suspension, procedural change, or request for information? Do not adopt a deadline because someone online wrote 90 days. Mark a possible escalation date in your calendar, but write beside it, verify, not guaranteed legal deadline. If you cannot identify the authority or the possible decision period, that is not a reason to invent an answer. It is a reason to ask for professional help. Remember our applicant whose document expires on Friday? At this point, we still cannot say approved, but we can identify what must be proven: when the application was submitted, whether the file was complete, which authority was responsible, what decision period may apply, and whether a clear written request went unanswered. That is the backbone of lawful escalation. Once the file is organized, send one precise written request, not 10 emotional messages. One accurate request through an official channel that produces proof of delivery. Identify yourself as recorded in the case. Include the process reference, submission date, and submission channel. State that no final decision has been received. Ask for the current status and, where legally appropriate, an express decision. If something is missing, ask the authority to identify it in writing. If there is concrete urgency, explain it briefly and attach proof: an expiring document, scheduled medical treatment, a confirmed employment obligation, a documented family need. Do not write your entire life story. Do not make accusations you cannot support. Do not send contradictory versions of the facts. Save the sent message, attachments, confirmation, and every response. Your request might say, "Please confirm receipt, identify the current status of process number, and inform me in writing whether any document or action remains outstanding. If the applicable period has elapsed, please provide the decision or explain the procedural basis for the continuing delay." That is not a magic formula. Formal words do not force a result by themselves, but precision creates a record. You are not weakening your position by communicating professionally. You are making the issue easier to evaluate. If there is still no meaningful response, choose the escalation lane according to your purpose. If you need to record poor service or obtain a reference number, review the authority's complaint channels and consider the livro amarello where appropriate. That records a complaint. It does not automatically produce a resident's decision. If you need an independent public administration review, ask whether contacting the Provedor de Justicia fits the facts. That office is not a substitute for every deadline or court remedy. And if you need a court to address a failure to decide, speak with a qualified Portuguese administrative lawyer about the possible CPTA route. This is where I want to be especially clear. A missed decision period may create an argument, a remedy, or a basis for judicial review. It does not automatically create the immigration benefit you wanted. A court request concerning inaction may seek a decision. It is not necessarily a court order granting the underlying application. Consider two anonymized files. The first applicant called repeatedly for 6 months. An employee reportedly said, "It should be fine," but there was no written confirmation, no reliable copy of the original upload, and no clear record of whether the application was complete. When the document expired, the applicant sent an angry message claiming approval had already been promised. Counsel could prove frustration and delay. Counsel could not easily prove the exact contents of the application, the date a complete file was received, or whether a requested document had failed to arrive. The case was not necessarily hopeless. It was slower, more expensive, and more uncertain. The second applicant faced a similar delay, but preserved the receipt, payment evidence, portal captures, delivery confirmations, and a dated chronology. The applicant documented a specific work obligation and made one precise written request for a status decision. Counsel still could not promise an outcome, but counsel could identify the disputed dates, the responsible authority, the practical urgency, and a possible procedural route. Notice what the stronger file proved. It proved that a request was made. It proved what documents were submitted. It proved follow-up and concrete urgency. It did not prove automatic approval. It did not prove that every delay was unlawful. It did not prove guaranteed compensation. Those are separate legal questions. Compensation may require proof of an unlawful act or omission, actual damage, causation, and other elements under the applicable rules. Inconvenience is real, but a folder of inconvenience is not automatically a compensation claim. European escalation is not a button that overrides Portuguese procedure either. European mechanisms can have different mandates, thresholds, and limits. Before pursuing one, ask whether it serves a clear purpose or merely consumes time while a domestic deadline approaches. When you contact a lawyer, bring the organized file, not a cloud of panic. Start with one page: who you are in relation to the procedure, what you submitted, what happened afterward, what is urgent, and what you want evaluated. Ask whether the lawyer regularly handles Portuguese administrative and immigration matters. Ask which authority and court may have jurisdiction, what deadlines they see, whether an internal step should come first, and what evidence is missing. Request the proposed strategy in writing. Ask for the scope of work, estimated fees, court costs, translation costs, and what happens if the authority decides after proceedings begin. Be wary of anyone promising automatic approval because the authority was silent, guaranteed compensation without reviewing evidence, or selling a secret court shortcut. Competent counsel can be confident and still acknowledge uncertainty. In fact, that honesty is one of the signs you should look for. There are urgent warnings you should not ignore. Do not travel internationally based only on the assumption that a pending application equals a valid travel document. Ask qualified counsel and the relevant official authority about your specific documents, nationality, destination, and re-entry risks. Do not ignore an official request because you believe the administration already has enough information. Do not alter screenshots or delete messages because they make the timeline look inconvenient. If your case involves family separation, an expiring visa, a refusal, detention risk, or a court deadline, treat it as urgent legal work, not as a question for a public comment thread. General information can help you ask better questions. It cannot replace advice based on your complete file. That is not a disclaimer designed to end the conversation. It is a warning designed to keep you from making an irreversible decision on incomplete information. Here is your 24-hour task. Open a secure folder and call it Silence File. Produce one page with 5 columns: date, event, authority, evidence number, and next step. Create an evidence index. Save the receipt, payment confirmation, portal status, appointment records, correspondence, delivery proof, and anything showing concrete urgency. Then write 3 questions. Which authority is responsible? What decision period may apply? What exact written response am I requesting? Do not answer those questions with a guess. Verify them through current official sources or with a qualified Portuguese lawyer. If you have already sent many messages, pause before sending another. Organize first. If you cannot identify the authority or possible decision period, mark that question in red and take it to counsel. The system is slow. Your preparation shouldn't be. Turn bureaucracy into accountability by making the record clear enough that another professional can act on it. Keep the central idea with you. Silence is information, but it is not automatically approval. It may show that a decision is pending, that communication failed, that a document is missing, or that a legally significant omission deserves analysis. Preserve proof. Calculate carefully. Make one precise request. Then choose the escalation route that fits your procedure. The Código do Procedimento Administrativo and the CPTA provide important legal concepts, but they do not turn every delayed immigration matter into the same case. Deadlines, presumed effects, court procedures, compensation, and European options depend on the facts and the law currently applicable to your procedure. Verify anything that could affect your status before you travel, file in court, or rely on a presumed legal effect. If this episode helped you replace uncertainty with a plan, save it and share it with someone facing an unanswered application. Before tomorrow night, produce 1 page, 5 columns, and 1 numbered evidence index. Then take that file to a qualified Portuguese lawyer for advice specific to your procedure. Do not pay for promises. Look for careful analysis, clear communication, and lawful action. Knowledge is your best defense. Document everything, act lawfully, and protect your future. Always consult a qualified Portuguese lawyer for your specific case. Your rights don't disappear at the border.